Hi, I'm David Horvath. I am an associate here at FH&P Lawyers. One of the primary questions that we get in estate litigation is what happens when your long-term spouse dies without a will. In those situations, the Wills, Estates and Successions Act is the governing body of legislation. That act indicates what should be done in this type of a situation. But the first question that's asked is whether or not you, as a surviving spouse, are a spouse as defined in the act. And what the act says a spouse is someone who has been married. So it's clear there was a wedding and you married, so there's a definite date. But if one's not married, a spouse is defined as two individuals living in a marriage-like relationship for at least 2 years. Now, what a marriage-like relationship is difficult. Each relationship is different and unique, but the courts have come up with some indicia of what that means. And these are not exhaustive. All relationships are quite unique, but some of these can be blending of finances, situations wherein one partner takes the financial burden of the relationship, situations where the couple has a child together, where they go on vacations together, where they act in public as a couple, their friends and family know them as a couple. All of these things indicate that there has been a marriage-like relationship, and it will depend on the facts of each case, but these help indicate to the court that this was a marriage-like relationship, and therefore, if it was for at least 2 years, the surviving partner is a spouse under the act. Now, what happens at that point is determining who gets the estate, and the estate includes any bank accounts, any money left over, property, real or chattels, meaning personal belongings, less any debts. So any debts will have to be paid out. Now, if you being the spouse are the only surviving member of the family, there are no children, then all of that pot of money and assets would go to you. But if there are descendants, it becomes a bit more complicated. So if there is a child of the relationship, for instance, the surviving spouse is able to retain the household furnishings and gets a preferential share of the estate, which is $300,000. Now, if the estate has less than $300,000, all of that money would go then to the spouse. But in a situation where the descendant or the child was not of the relationship, so for instance, if you being the spouse, you were a step-parent, then in that type of a situation, the spouse would get a preferential share of the estate in the amount of $150,000. Again, if the estate, after debts are deducted, is less than $150,000, then all of that money goes to the spouse. And this is all dictated by this one act. So when you have a will, you get to decide who gets what. So these types of situations are a prime example of why we need wills and why we shouldn't let just the act handle these types of situations, because it can get very complicated after these analyses are done. So if you have any litigation issues involving an estate, or have questions about a will, or any of these issues, feel free to contact FH&P Lawyers.